We will continue our discussion in Industrial Safety, Module 6. Today we will deal with the Workmen Compensation Act 1923. And also, this act was modified in 1924. First of all, the objective of this act is that in case of an injury to an employer during the employment time or during the work time, how the employer can compensate for that. So the objective of this act is that in case of an employment injury, compensation should be provided to the injured workman, and in case of his death, to his dependents. So if he is dead, the compensation must be given to his dependents. So the objective of this act is the compensation. Okay, how the compensation can be given by the employer to the family or the employee himself if he is alive. Employer to pay compensation. Okay, what is the criteria? Okay, in case of a personal injury is caused to a workman by accident arising out of and in the course of his employment, his employer is liable to pay compensation in accordance with the provision of the act within 30 days from the date. So when it fell due otherwise, he would also be liable to pay interest and penalty. Okay, if he should pay the compensation within 30 days of accident and he is not able to do that, he would have to pay the interest and penalty. Okay, so that is the condition in case of compensation. Okay, if the injury is happened during working time. Okay, so there are cases when the employee is not liable. Okay, what are the cases? In case the disablement of workman is 3 or less days. The workman is disabled for 3 or less days. Also, except in case of death. Okay, within 3 days, if he is dead, then the employer should pay the compensation. When the injury is caused due to influence of drink or drug taken by the workman or employee, or upon his willful disobedience to obey the safety rules or removal of safety guards by him. If he is drunk and he is working and it causes injury or accident, the employer is not liable to pay the compensation. And or the workman is not obeying the safety rules and he removes the safety guards, okay, by intentionally. Okay, then the employer is not liable to pay compensation. Otherwise, he has to pay the compensation, and in case of death, or if the disablement of workman is less than 3 days, then he is not liable to pay compensation. If he is dead, then he has to pay compensation anyhow. So then what is the amount of compensation in case of death? An amount equal to 50% of the monthly wage multiplied by the relevant factor as given in section 4 of the act, or rupees 80,000, whichever is more, that should be paid. Okay, so 50% of his monthly salary and plus the given amount given in section 4 schedule 4 of the act, or 80,000 rupees, whichever is more, that should be paid if he is dead. In other ways, in case of permanent total disablement, it is 60% of the monthly wage, or and then the relevant amount given in schedule 4 of the act, or 90,000 rupees, whichever is more. Okay, in case of permanent total disablement, he is not dead but he is permanently disabled, then there is 60%, 10% rise compared to the first case, plus the relevant factor given in schedule 4, or 90,000 rupees, whichever is more. Then third case, in case of permanent partial disablement occurs, then the compensation is proportional to the disability arrived at case 2. Okay, partial disablement, permanent partial disablement, then in that case the proportional the percentage of his monthly salary, then proportional percentage relevant factor given in schedule 4 of the act, that much amount. Okay, so these are 3 cases of amount of compensation. Then What is a notice? An injured person or his dependent have to give a notice to the employer to pay compensation. The dependent or the employee has to give a notice. Otherwise, the employer won't be able to pay the compensation. Okay, so if he is not well informed, then he cannot do anything. Then claim. What about claim? Upon the failure or refusal of an employer to give compensation, an application is to be made in Form F to the Commissioner under the Workmen Compensation Act 1923. And who is the Commissioner? He is the Assistant Labour Commissioner or the Labour Conciliation Officer of the area where the accident took place, or where the claimant ordinarily resides, or where the employer has his registered office. Okay, so a claim, if the employer is failed or is refused to give the compensation, an application, a complaint in a particular form F should be given to the commissioner under the Workmen's Compensation Act 1993. The commissioner is the assistant labor commissioner of the area where the accident took place, or where the claimant or the employee is originally resides, or where the employer has registered his office. Okay, so after hearing both the parties, the commission decides the claim. So this much is about the Workmen Compensation Act. Next act is the Public Liability Insurance Act. Okay, 1991. This is an overview. The Public Liability Insurance Act 1991 provides for mandatory public liability insurance. It's mandatory. The public liability insurance is mandatory. Insured properly. Under the Act, the companies need to take for installing, handling any hazardous substance notified under the Environment Protection Act. If the companies need to be take for hazardous substance or hazardous machines for installing or handling, this should be taken care of. The growth of hazardous industries, processes and operations in India has been accompanied by growing risk to accident. Okay, there are a lot of hazardous industries like the dyeing industry. Okay, then chemical industry. All these are very dangerous industries, and processes are there. So these can be accompanied by growing risk to accidents. It's very much prone to accident. So these should be taken care of. Therefore, under Public Liability Insurance Act 1991, every owner before starting to any hazardous substance have to take out one or more policies. He has to insure his company, or he has to insure his employees, he has to insure his machines if it is possible, with one or more policies before taking any hazardous substance. To the Public Liability Insurance Act 1991 has been enacted for providing immediate relief to the persons affected by accidents. So why it is to be mandatory? It is for providing immediate relief to the persons affected by accidents. So application. Under the Public Liability Insurance Act, an application for relief made by the applicant to the collector within 5 years of the accident after giving notice to the owner and the insurer and giving the parties an opportunity of being heard shall make the award determining the amount of relief. Okay, so if under this act, Public Liability Insurance Act, an application for relief is made by the employee, okay, those who got injured within 5 years of the accident. The application should be given within 5 years of the accident. So then after giving notice, and the collector give the notice to the employer or owner or insurance company, and then giving the parties an opportunity to being heard, then shall make the award, shall make the decision about the fund or the amount. Then establishment of relief fund. There, the Section 7A of the Public Liability Insurance Act empower the central government to make an environmental relief fund. Okay, so Section 7A gives the central government the power to establish an environment relief fund. From that fund, the government can then contribute its own contribution for the insurance. Okay, then power to give direction. Section 12 of the Public Liability Insurance Act 1991 empower the central government to issue direction in writing to the owner, officer or agency. The insurance agency to the insurance officer, to the owner of the industry. So it gives Section 12 of the Act gives the power to the government, central government. Then offences and penalty. Punishable with imprisonment for a maximum period of 1 year and 6 months, but it can be extended to 6 years. Okay, this is the offense. Okay, penalty. So this much is about. Thank you.